joining another episode of the Real Planning Podcast, where real estate and estate planning converge. It's Real Planning. Today I have here in the studio attorney Martha Prizio, licensed to practice in New Hampshire and Massachusetts, concentrating in real estate and title. And we also have attorney Morgan Jones, licensed to practice in New Hampshire and Vermont, also concentrating in real estate, title, and settlement services. So today, Martha and Morgan are here to discuss the many ways in which one can hold title to properties, how that title ownership interest can change, whether or not it's in its entirety or sometimes in a combination scenario where one party might buy the other out. So, attorneys Martha and Morgan, take it away.
Great, thank you, Jackie. So first we're going to talk about one of the common questions that we get, which is,
Absolutely.
Should I hold title in a trust?
And that is a great question.
Thank you. And so, Martha, what would you say are the benefits of doing that?
I would say the primary benefit of holding title in a trust is going to be probate avoidance. You're able to direct who will ultimately take ownership of a property without entering into what some may feel to be a lengthy and costly probate process.
So, Martha, what are the costs that are usually involved in that? Because that's one of the next questions we get.
Absolutely. So the primary cost is going to start with creating the trust itself. So you're going to want to engage an attorney, consultant attorney who is an expert in trust and estate planning and trust drafting. And the fees that will relate to that trust drafting are going to depend on the complexity of your estate plan. Your plan might involve ownership of property, but it might also involve other accounts and assets. And so ultimately, the cost for those items are going to factor into the plan itself.
That makes sense.
And otherwise, there's also going to be a deed drafting fee. So if you already own property and the property is held in the names of an individual, there's typically a moderate flat fee for drafting a deed and placing the property into a trust. However, there could be other complexities involved. For instance, multiple properties, different owners, perhaps a new legal description drafting, so the cost could depend on those additional factors as well.
That makes sense too.
The next cost could be recording fees. So if the property is not already in the trust, those fees are set by the state, and so ultimately those fees would be passed along. And one of the most important considerations would be transfer tax. Whenever you transfer title to a property, you ultimately have to pay a tax to the state, gone through the Department of Revenue and set by the statutory section RSA 78B in New Hampshire. And historically, when putting properties in and out of trust, you would charge the minimum transfer tax fee of $40. However, the Department of Revenue realized that ultimately that was an unnecessary fee, perhaps for people moving property in and out of trust, that they're just doing it for a testamentary substitute. They're just transferring property in and out of trust to avoid probate matters. So ultimately, the state did pass the statutory section also in RSA 78B2, 21 and 22, and there are certain exemptions under which you can avoid the tax completely. However, if you do have a property, you're moving property in and out of trust and there is a mortgage involved, you may still have to pay that transfer tax $40 minimum, as the state acknowledges that someone may be assuming responsibility for the mortgage, and it's not simply a testamentary substitute, but that also there may actually be consideration in the form of taking responsibility for that mortgage. Maureen, are there any Vermont distinctions in terms of transfer tax?
Yes, absolutely. Of course, recording fees are just a little bit different in Vermont, but the concept is the same, and most of the other stuff is the same over here in Vermont. But transfer tax is a little bit different. In this one area where you're most likely going to be exempt from transfer tax in this scenario with the type of trust that people usually use for this, but it really turns on the terms of the trust itself. So you're going to want to talk to a Vermont real estate attorney about your specific trust to make sure that it's exempt from transfer tax to put the property in there.
It sounds like there are a lot of unique exceptions where you really do want to use the advice of an expert that's in the business of making these conveyances. And also, Martha, you mentioned something about recording. It seems like a lot of people might go through the trouble of forming a trust, but I've heard that a lot of people then don't do anything with the trust, and they forget that they have to actually convey their real estate into the trust in order to protect that asset. So that was really
That's a
nice
great
to
point,
remember
Jackie.
that.
And that's why it's so important to engage professionals that are engaged in the business of handling real estate and estate planning. And that's what we actually offer at our firm. We have many resources, including our wonderful Candace O'Neill, who is well versed in New Hampshire and Massachusetts estate planning, and works collectively with the real estate team.
At the moment, I don't have a Vermont Candace yet, but hopefully we will someday. But I work with some wonderful attorneys in other firms that I'm happy to give referrals if people want to come before their trust is set up and get some help with that, as well as the real estate, putting the real estate into the trust.
And then one additional fee that a lot of times people don't think about is perhaps that you're going to want to consult an accountant and you're going to want to open up a bank account. The accountant can assist twofold. One, in determining whether or not you need to establish a separate bank account for the trust, and then also to determine whether it would make sense to have a separate tax ID for the trust.
Yes, absolutely. Yeah, talking to an accountant is absolutely crucial.
What happens when someone is selling real estate and they own the property in a trust, and so when they sell, their proceeds are made payable to the trust, but they tell you at the real estate closing that they don't have an account in the name of the trust? What happens?
That's a great question, Jackie. And I'll actually take a step back first and say, what, as a seller, would you actually need to be prepared as a whole to bring to closing or establish your right to actually sell the property? And that starts right up front with how exactly do you hold title to the property? When you take title to property in New Hampshire and in the name of a trust, there should be the trustees' names, trustees as trustee of the particular trust. If, when you go to sell the property, the status of who the trustees are has changed, then you need to be prepared to actually provide a copy of the trust itself, the trust agreement, or in lieu of the trust, you would be able to prepare a certification of trust pursuant to RSA 564B 1013. And that statutory section indicates that you are not obligated to provide a full copy of your trust, which many people may feel very uncomfortable with providing the details of their entire estate plan to a third party. So we are able to rely on that very specific certification of trust that's authorized by that statute. And additionally, the seller should be, of course, as always, be prepared to provide a deed, but that deed needs to be coupled with a trustee certificate, either embedded in the deed itself or provided separately. And that deed is really the authority, the evidence of authority that the trustees have the ability to act. And so ultimately, when you've put the property into really what we could call sort of an entity, a trust, you need to be prepared that you're going to accept your proceeds. The owner of the property as the trust will need to accept the proceeds made payable to the trustees of the trust, or simply the trust name itself. And if you do not have a tax ID that is specific to the trust itself, then you need to be prepared to provide a tax ID, i.e. a social security number, that's tied to typically one of the grantors, the creators of the trust, is the individual that files taxes for that trust.
It seems as though if you spent enough time and care and spent the money to create a trust, your trusted team of expert advisors, your attorney and your CPA, your tax advisor, advised you to put this trust together for important probate avoidance and for tax planning and strategy. You should also take the time and care to establish that bank account so that then when you liquidate the real estate asset, you're not exposing the liquidated funds to probate. You should take proceeds in the name of the trust so that you have the same benefits and protection for the liquid money as you did for the real estate.
And likewise, when we as settlement agent are handling a transaction, we oftentimes do not look at the entirety of your trust, nor should we, be making decisions as to how the money should be flowing through your trust. If you take title in the name of a trust and you're selling in that same capacity, then we need to make sure that the assets are going to flow through the trust, which is why we can't ultimately make checks payable to individuals, because we'll never know perhaps how that money should flow to beneficiaries. Is that similar to how
absolutely.
that would work in Vermont?
Vermont is very, very similar. We have a complementary statute for the certificate of trust, so that the entire trust doesn't have to be provided. Really, the only difference is that is what we record as a trustee certificate, instead of having the simpler version that's recorded in New Hampshire as compared to the one that is a reliable substitute for the full trust. We use the same one for both situations, but otherwise it's the same. All right, and then another question that we get is, we've already started to answer some of that, as they're very, very similar, is what happens if you're going to refinance or finance the property?
It's another great question, Morgan. So with a finance or a refinance of a property, as we just discussed, there is the need to provide a copy of the trust, or again, that certification of trust that contains all of the necessary information that one would need to determine whether or not a trust complies with the lender's guidelines. And the far majority of lenders are going to require the trust to meet the Fannie Mae Freddie Mac guidelines, and those are secondary mortgage market guidelines. So we have to remember that a trust may not meet secondary mortgage market guidelines, but that does not necessarily mean that the trust is not a good trust, or that it's not a trust that's serving the purpose that it was meant to meet. And furthermore, we also want to recognize that even if a trust does not meet these guidelines, it could still act as an appropriate mortgage, or it could still properly encumber or have the permission to encumber a property with a mortgage. However, because so many lenders do want the trust to meet the secondary mortgage market guidelines, you need to be, again, prepared to provide a copy of that trust or certification of trust. And typically the crux of the guidelines is really that you're in control. The person that is going to be acting as borrower of the trust, the borrower on the loan, is also going to be the person that created the trust. They are a trustee of the trust, and the trust has taken title to the property and is the actual owner, because the lenders want to make sure that there is the appropriate authorization in place and control in order to enter into a mortgage loan transaction. We'll also need that trustee certificate that we talked about before, but this time, instead of authorizing the trustee to sell, it will be authorizing the trustee to borrow and to encumber, which means to mortgage the property. And I'll just point out another thing that folks usually don't think about. Oftentimes people aren't attending the closing. Sometimes they're not physically in state and able to appear, or maybe they're not well enough to attend. So oftentimes people would like to have a power of attorney put in place, and we need to remember that with a trust holding title, the appropriate delegation document is going to be an appointment of agent. So you as trustee would actually be delegating your authority to act as trustee to another individual. And so we need to make sure, we'd be wanting to make sure that the trust doesn't prohibit that from taking place. And then we also might be asking that the power of attorney also be executed, because there may be documents that need to be signed in your individual capacity. So I would remind people to be aware
point.
And not shocked
if
somebody
absolutely.
requests
and let us
those
know
things
far enough in advance to make sure we get that done, and that everybody has
Good
time to sign it, not stressed out when under time constraints.
And I'll also just point out, and not totally related to the subject, which is not every single lender will allow you to use a power of attorney or appointment of agent period to enter into a loan transaction. They either want you to facilitate a mail-away closing or appear for the closing, since it's such an important transaction.
Makes sense.
Definitely important to pick a closing date that you are likely to have the ability to attend, and certainly If you can't attend, ask your lender in advance, because the lender might have very specific requirements on how a power of attorney is drafted, and they might require particular language be included in a power of attorney. So believe it or not, sometimes even your general powers of attorney that you might already have in place, the lender may not allow. It is their money after all, so they do get to make certain rules, and they might require a transaction-specific power of attorney, whereby you're granting permission to another party to act only in relationship to that particular transaction, that property address for a certain purchase price for a certain loan amount on a certain date only.
And I would just want to point out, lastly, that you want to make sure, if you're working with an estate planning attorney, that you are providing them with all the details that they would need in order to successfully transfer property into the trust. We so oftentimes see properties transferred into trust that it's only a portion of your property ends up in the trust because there were multiple deeds that you might have taken title to the property in. So you want to make sure that if someone is not completing a title examination, that you are making sure that you've provided them with all of the most recent documentation to make sure that your property ends up in trust as you would like it to.
Thank you for joining us, Morgan and Martha. This was part one of our mini-series on the many ways in which we can hold title to real estate. Up next will be episode 9, talking about holding title in an entity or a corporation.